Don't wait until it's too late. Join before you need us. Understanding grievances and disciplinary procedures. Most people go to work expecting to do their job and be treated fairly. Unfortunately, problems can arise. You may feel you have been treated unfairly, bullied, unfairly overlooked, or subjected to poor working practices. Equally, you may find yourself facing disciplinary action from your employer. In either situation, understanding the process and having the right support can make a significant difference. A grievance is a formal complaint raised by an employee about a workplace issue. This could involve concerns about bullying, discrimination, harassment, health and safety, pay, working conditions, or unfair treatment. Before submitting a formal grievance, employers will usually expect employees to try and resolve the matter informally, often by speaking with their line manager. If the issue cannot be resolved informally, a formal grievance may be submitted, triggering an investigation and a formal meeting where the concerns will be considered. A disciplinary procedure is different. This is the process an employer follows when they believe an employee may have breached workplace rules, policies, or standards. Disciplinary matters can range from concerns about attendance and conduct to allegations of misconduct or gross misconduct. Depending on the circumstances, the outcome could include a warning, a final written warning, or even dismissal. Human resources departments are there to support the employer. Both grievance and disciplinary procedures are serious matters. They can affect your employment, reputation, well-being, and future career prospects. While employers have policies and procedures that must be followed, it is important to remember that management represents the interests of the organization. Human resources departments are there to support the employer in managing its workforce and ensuring policies are followed. They are not independent advisors for employees. This is why having independent trade union representation is so important. An experienced independent trade union representative is there to support you, advise you, and ensure your employment rights are protected throughout both of those processes. They can help you understand policies, prepare statements, review evidence, accompany you to meetings, challenge procedural errors, and make sure your voice is heard. Most importantly, they are there to represent your interests, not the interests of management. Many employees only discover the value of trade union support when they find themselves facing a difficult workplace situation. By that point, it may already be too late to access trade union representation for an ongoing case. This is why joining a trade union before problems arise is one of the most important steps any worker can take to protect themselves at work. The Workers of England Union provides independent support, advice, and representation for members facing workplace disputes, grievances, disciplinary hearings, and other employment issues. Our representatives understand workplace procedures and are committed to standing alongside members when they need support the most. If you are experiencing problems at work, do not face them alone. Contact the Workers of England Union for advice and assistance. If you are not yet a member, consider joining today so that you have the protection and representation you may need in the future. At the Workers of England Union, we welcome every member and will always endeavour to provide support wherever we can. However, just as you cannot buy car insurance after an accident and expect to be covered, trade union protection is most effective when membership is already in place before workplace problems arise. That's why we encourage workers to join early, so that help, advice, and representation are there when they need it most. Stephen Morris, General Secretary, Workers of England Union.